What happens if you die without a will? That's a great question, and we're going to get into that today. I'm Ellen Mitchell, your heels on the ground in the Miami-Fort Lauderdale area. And in this channel, we're going to talk about probate, trust, senior relocation, guardianship, and everything in between. So what does happen if you die without a will? Well, it really depends on what state you're in, but you're definitely going to go through probate. We're in the state of Florida. I am not an attorney. I am a licensed residential realtor. So any information that I give, you should consult with an attorney to confirm. Every situation is different, every state is different, and I'm not equipped to give legal advice. My understanding, if you die without a will and you're married, the spouse, the property, the monies, the retirement account, everything will transfer to your spouse. What if you have children? Doesn't matter. Everything's going to transfer to your spouse. But what if, like me, you're remarried? I was married and I have children from my first marriage. I'm remarried and don't have any children from my second marriage. If I did not have a will, the way that it would work is my current husband would inherit 50% of any assets that I have, and my children would inherit the other 50% because they are not children from this marriage. When I say children, I mean adult children, any children that I had outside of this marriage. Adopted children, I'm adopted myself, so I have a heart for this. Adopted children are in the state of Florida are considered your children, so they will inherit the same as any of your other children. Going through probate can be a costly and time-consuming process, so I really do encourage people to do their estate planning up front, but if it's too late, it's too late. You would need to immediately consult a probate attorney. So you want a probate attorney in the state that you're in, and you're going to need to meet with them and get together all of the assets that the person had. Real estate, bank accounts, retirement accounts, jewelry, personal property, and you're going to make an appointment and meet with that probate attorney. They're going to have to open a case in probate court. And in that, the court is going to appoint a personal representative. So if you have a trust, the trustee is the person that administers everything. If it goes through probate, the personal representative administers everything. If you have a trust, it's not going to court unless, God forbid, there's a lawsuit. The trustee will administer the trust, and it will distribute everything to the heirs, and it will never see a courtroom unless something goes wrong. In probate, it's going to go to court, and you can sell a home during probate. A lot of people ask me that. Can I sell a home before the probate is closed? Yes, you can. But you have to get letters from the court. You have to get permission from the court. So when I take a listing and the home is in probate, I always add language that the sale is subject to probate court approval. I always educate the other realtor when they're bringing a buyer that this contract is subject to probate court approval. If their buyer is a tenant and their lease is going to be up in 45 days, and in 46 days they're going to be homeless, this is not the home for them to buy. Typically, we can close the home in a reasonable amount of time, but because we're waiting on the court, sometimes we're waiting for the creditor period, which we'll discuss in another video, there has to be flexibility with the closing date. So the more information you have up front, the more information that's conveyed to all parties, the more smooth the transition will be. The moral of the story, and what I would really encourage everyone to do, whether you have a little bit of stuff, no stuff, or a lot of stuff, is get your estate in order. Even if that just means getting a healthcare surrogate, a power of attorney. What if, God forbid, you went out today and you were in a car accident and someone had to make decisions for you, who would that someone be? You don't need to have assets to have those kind of things happen. And I've seen time and time again those things happen when the proper documentation was not in place, and it can be a real nightmare for the family. So my takeaway for this is, can you sell a property when it's in probate? Yes. What can you do if the person dies without a will? You can get together with a probate attorney immediately, and that probate attorney will file in the probate court, and they will ask for a personal representative to be appointed. But you can avoid all of that by going ahead and taking care of your affairs up front. I hope this has been helpful. It may have made you think of more questions than it answered. If so, please write below. Let me know any comments, questions, suggestions that you have. Again, I'm not an attorney. I'm a residential realtor. So this is my interpretation of the information. Always seek legal advice. And please like and subscribe.